welcome to Crime in Court. My name is Heather, and this is, as you can see from the thumbnail, episode 57, The Canton Cover-Up Commonwealth versus Karen Reed. And in this episode, we're going to be going over the latest court document from the defense where they double down on the Constitution and express Karen's constitutional rights and reaffirm them, I guess, back them up with some actual knowledge. So we're going to go over this opposition, or sorry, no, it's a reply to the Commonwealth's opposition to her motion to dismiss. So let's start from after the mistrial was declared, very shortly after, a couple days after, or was it? I don't know. I don't know. It was very shortly after. The defense came forward with a motion to dismiss charges 1 and 3. So there's 3 charges that she officially had been up against. First charge was homicide second degree, which means intent, maliciousness, knowing. Number 2 was the manslaughter charges, which could be either she didn't know it, like it was an accident and she didn't know she did it, or it was an accident by her own negligence or something along those lines. And then it had all the lessers, including like the OUI charges with it. There wasn't a separate OUI, it was a manslaughter with OUI. And then the third charge, and remember, that's the charge that they got all caught up on, and that page was the most confusing. There were 3 separate pages for the jury slips because there was a page for each of the charges. But they were also told not to fill anything out and not to tell anybody about their decisions until a unanimous verdict has been reached, which I think they were waiting on. Well, I don't want to speculate too much, but I think they were waiting on more instruction once they gave that charge, or once they gave that final note to the judge. I think they were waiting to be asked, like, okay, is that on all charges? Is it on one? Or, then they would have spoken up. But I think that they didn't know that they could write it down yet because the instructions were just so confusing. We went over that in the last episode. So, and then the third charge was just leaving a scene of where there was injury or loss of life. So that again includes like she needed to know about it. So that was, knowledge of her having done it. So I think they might have been hung up on maybe she did it, but she didn't know she did it. And I don't know how because none of the science proves that he was hit by a car, but that's okay. Let's move on from that. So the jury, 4 jurors have come forward either directly to the attorneys of Karen Reed or through an intermediary saying that they were unanimous on charges 1 and 3 for not guilty. All of them, all 12 of the jurors would say that, they said. And it was just the manslaughter charges that they were hung up on. So after that, Commonwealth came out. They opposed that, obviously. They're like, well, no, screw the Constitution. We don't care about double jeopardy. Whatever. Nobody needs to have constitutional rights here in Massachusetts. So, you know what? We're going to charge her again. That's what they said in their motion, basically, pretty much. So, this is the defendant's, Karen Reed's reply to the opposition, to the Commonwealth's opposition, if that makes any sense. So I'm going to shrink myself here and let's get started. So, sorry, defendant Karen Reed's reply to the Commonwealth's opposition to her motion to dismiss. Now comes the defendant Karen Reed by and through undersigned counsel and hereby respectfully submits this reply to the Commonwealth's opposition to her motion to dismiss. The Commonwealth's opposition is perhaps most notable for what it does not dispute that, according to information from 4 deliberating jurors, the jury had reached a unanimous decision that Ms. Reed is not guilty on two of the three charges pending against her, namely counts 1 and 3, as I've already explained. All right, so the Commonwealth's insistence that Ms. Reed must nonetheless be forced to run the gauntlet, excuse me, once more is based on several clear fallacies. First, while the defense was given an opportunity to be heard on other issues arising during jury deliberations, i.e., the appropriateness of a Tui Rodriguez instruction, that was the final instruction that they were given. So while defense had an opportunity to give comments about that, they didn't have an opportunity to actually say no mistrial or we object or whatever. They didn't have an opportunity to say anything, as we'll further discuss. So, first, while the defense was given an opportunity to be heard on other issues arising, such as the appropriateness of the Tui Rodriguez instruction, the defense was provided no opportunity to be heard regarding the declaration of a mistrial. Rather, upon receiving the final jury note, the court sua sponte, which means she just on her own accord took it up on her own volition to say it's a mistrial. She didn't ask for feedback or commentary or anything, and she declared a mistrial with no warning to or solicitation of objections from the parties. So she didn't allow objections or any kind of comments. Second, the jury note did not explicitly indicate an impasse on all charges. To the contrary, it was readily susceptible to the interpretation proven correct based on information received post trial from deliberating jurors, that the deadlock applied only to the multiple offenses included within counts 2 and not to counts 1 and 3. Third, and finally, the defense respectfully submits that neither the Commonwealth nor the court carefully considered alternatives before declaring a mistrial, and they did not. She didn't ask any questions. She just said, okay, mistrial, bye. It was almost that quick. The record reflects no discussion of any such alternatives, including, importantly, inquiry regarding whether the jury had reached an impasse on all, as contrasted to just one of the counts. The underlying idea of the constitutional protection against double jeopardy, one that is deeply ingrained in at least the Anglo American system of jurisprudence, is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense. Even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden of the accused, prolongs the period in which she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. Sorry. Yes, that is, I mean, it doesn't get more simplistic than that. You don't get to get tried again by the state. I mean, you don't have to, I mean, that's like the foundation of our justice system is trust and knowing that it's supposed to be fair somewhat, at least. So it's not fair if the Commonwealth can just keep coming after you. Thus, whether the jury acquitted Ms. Reed or, alternatively, was merely not deadlocked on the relevant counts, the Constitution compels the same result: dismissal. So, whether the jury acquitted her or was merely deadlocked on the was merely not deadlocked on the relevant counts, the Constitution compels a dismissal. Given the unambiguous post trial evidence, it would simply be wrong to require the defendant to obtain two acquittals from two different juries for the same crime. I mean, and like that one explanation said, there's a possibility she could get an innocent person could get convicted after already being acquitted, which the system's not supposed to work that way. We're supposed to have trust that it works to protect us from that. Commonwealth's leading argument is rooted in pure formalism that no verdict was entered on the record in court. But precisely this formalistic mode of analysis has been consistently rejected by the United States Supreme Court and Supreme Judicial Court in a string of precedents spanning more than 100 years. So um, that argument that the Commonwealth had, like, well, they didn't say it on the record, that doesn't hold any weight anymore. For the last 100 years, more than 100 years, the Supreme Court has been ruling in favor of the defendant in those cases. All right, so indeed, the prohibition against double jeopardy was plainly intended to condemn the abhorrent practice of English judges exercising a power to discharge a jury whenever it appeared that the Crown's evidence would be insufficient to convict. The Commonwealth's heavy resilience. Should I read that footnote? Yeah. Okay. So the primary authorities cited by the Commonwealth in support of its position on this point are a rare or pair of opinions from 1831 and 1878, respectively. Oh my God, I can't talk today. Sorry. I'm saying the right word. I'm not saying the right word. The problem. Brain doesn't want to match up with the tongue. So this they're citing, or the Commonwealth uses as its precedents, their 1831 and 1878 laws, neither of which addressed constitutional double jeopardy protections in any respect. So that's what's lacking in their uh, the laws that they're applying to defendants. Um, In any event, state law requirements are not binding as to what constitutes an acquittal under the United States Constitution's Double Jeopardy Clause. All right, so the Commonwealth's heavy reliance upon Bluford versus Arkansas fails for reasons set forth in the defense's opening motion. In that case, after the foreperson reported that the jury was unanimous against conviction on certain charges, the jury was sent back to continue deliberations. The foreperson's report was not a final resolution of anything, and there was no indication at the conclusion of deliberations that it was still the case that all 12 believed the defendant was not guilty of capital or first-degree homicide. Here, so that was the case there. They were still in the process of deliberating. They weren't done yet. In this case, they were done. So here, by contrast, four deliberating jurors attest that there was a final unanimous agreement that Ms. Reed is not guilty of second-degree homicide persisting through the conclusion of deliberations. So until the very end, they were all unanimous that she was not guilty. According to one such juror, Juror D, after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and 3? Alan J. Jackson that's from the affidavit from Jackson. Most importantly, unlike Bluford, this was not a case where the defendant was charged in a single count which incorporated lesser included offenses. Indeed, the Arkansas law at issue in Bluford did not permit the jury to return partial verdicts of acquittal. So that's a big difference too. They weren't given or didn't have the option for partial verdicts Whereas in this case, they could have had a split verdict all over the place, not guilty on counts 1 and 3, and then they could have gone guilty on 2 if they all agreed on that, which I hope, let's hope 12 people aren't that either naive or easily manipulated. So most importantly, unlike Bluford, this was not a case where the defendant was charged in a single count, which incorporated lesser includeds. Instead, they didn't have the option for a partial verdict. Here, by contrast, the defendant was charged with 3 standalone counts, and state law expressly allowed for partial verdicts on any charges with respect to which the jury was agreed. Only if the jury in fact was deadlocked on all 3 should a mistrial on all 3 be declared. Any other result would require either a verdict, if a unanimous one had been reached, as the affidavits in this case reflect, or at minimum, further deliberations. The lack of manifest necessity to support a mistrial provides a second independent basis for dismissal. While there is no doubt that a jury deadlock may constitute manifest necessity, the Commonwealth unsurprisingly cites no support for its contention that a deadlock on some, but not all, separately indicted charges supports a declaration of a mistrial with respect to all counts, contrary to the Commonwealth's characterization as unambiguous. Where was the I missed a footnote. Oh, it was from the affidavit. It's just citing another case. All right. So the jury note at issue here was facially susceptible to 2 alternative interpretations. One, that the jury had reached an impasse as to all charges, or 2, that the deadlock applied to only some of those charges. For example, on multiple lesser included allegations within a single count, such as count 2. The information received from jurors post trial proves the latter interpretation was correct. The jury's failure to expressly mention its agreement on counts 1 and 3 is understandable in light of the court's instruction that it should continue deliberating until it had reached a final verdict on each charge. Given that there was no deadlock on 2 of the 3 counts, it follows that there was no manifest necessity to dismiss the jury without receiving its verdict on those 2 charges. So that's a great point. She didn't have to, to declare a mistrial. If I could get my words out. She didn't have to declare a mistrial because there was a verdict on those charges. So therefore, there was no need to declare it. All right, so the defense does not suggest that the court was required to give the jury new options for a verdict, only that it should have asked the straightforward question of which of the separate indictments the professed deadlock related to. Let me read that again. So the defense does not suggest that the court was required to give the jury new options for a verdict, only that it should have asked the straightforward question of which of the separate indictments the deadlock was related to. Hold on, my dog needs her blanket. She's so spoiled. All right, we're all good now, I think. All right, so in essence, the Commonwealth's contrary position asks this court to close its eyes to the possible, or even, as here, very likely, existence of partial unanimous verdicts on some, but not all, separately charged counts to avoid the risks of juror coercion. The Commonwealth utterly fails to acknowledge that Roth, Bluford, and a juvenile are all clearly distinguishable because they all arose in the context of lesser included offenses contained within a single charge. The Roth courts, so these are all whatever arguments that the Commonwealth has been using to quote or to argue their case that Nick Heron doesn't get an acquittal for whatever reason. All right, so the Roth court's concern about coercion makes sense in that context. When the jury reports a deadlock on one charge, follow up questioning regarding the possibility of reaching a verdict on a lesser included offense would imply that the jury should consider conviction on that lesser offense. But this logic does not extend to the present circumstances, and no existing precedent cited by the Commonwealth requires judges to disregard the possibility of partial verdicts when the verdicts would be on standalone separate charges such as those in the current indictments. I hope that made sense because I don't think I can reiterate what that just said. All right, so Mass R, Crim P 27, reporter's notes. Okay, no, sorry. There is simply nothing coercive about asking a jury reporting a deadlock that fails to specify which counts the deadlock relates to. The single question of whether its deadlock is on certain but not all counts, and if it has reached a unanimous verdict on any counts. So it's not a coercive tactic, or it wouldn't be coercing some kind of a verdict if you ask those kinds of questions. Sorry, I gotta find the ends of all these quotes and things. I don't think they're fun to read. All right, so the inflexible prohibition on judicial inquiry regarding partial verdicts advocated by the Commonwealth would inevitably undermine defendants' important and constitutionally protected interest in being able, once and for all, to conclude their confrontations with society through the verdict of a tribunal that they might believe to be favorably disposed to their fate. So a jury of your peers, you're supposed to have that option. And um, it just wouldn't be right to it just isn't right. It's not constitutional if you're going to try her again because she should be able to say, I'm acquitted and I'm done with these charges. I shouldn't have to go up against them again. And the danger of unfairness to the defendant from multiple prosecutions exists when a trial is aborted before it is completed, as well as when the defendant is actually acquitted. Commonwealth's proposed rule would also undoubtedly hinder law enforcement interests by precluding courts from asking whether a jury may have reached a guilty verdict on some but not all standalone counts. The Commonwealth's attempt to shift blame to the defense overlooks the black letter rule that the prosecution alone bears the heavy burden of establishing manifest necessity for a mistrial. The defense's request for a Tui Rodriguez instruction did not, of course, reflect any implicit concession that the jury was deadlocked on all counts, nor did it commit the defense to any position regarding whether the court should sua sponte declare a mistrial. That's correct. Just because you ask for the Tui Rodriguez doesn't mean that you are going to totally agree to having a mistrial declared without any ability to respond. A discussion with counsel, such as that occurring twice earlier in response to jury notes, and either the consent of the defendant to a mistrial or further judicial inquiry of the jury, instead was required. It is indisputable that the court provided no opportunity for defense counsel to be heard regarding the declaration of a mistrial. I love that wording. It is indisputable. There's no dispute about it. She said, here's the note, blah, 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 blah. I'm not going to make you guys have to, you know, alter your opinions or, compromise anymore. So goodbye. And like that, it was a mistrial. Snip of a finger. In short, mere silence, absent an opportunity to object, does not amount to consent. Yes, Adam Lally. Get words right. Words and meanings matter. And so if he's saying just because they didn't object, that means that they consented, that's not the same thing. Cases relied upon by the Commonwealth are readily distinguishable on this basis or even support the defense position. All right, that's that for that. Um, in only one case cited by the Commonwealth, Fuentes versus Commonwealth, Mass 1017, 2007, was the defense, as in the present case, afforded no opportunity to be heard before a mistrial was declared. But there, the Commonwealth fails to mention the crucial fact that the jury's note preceding the declaration of a mistrial expressly stated that the jury could not reach a unanimous verdict as to either of the two indictments. In those circumstances, while the more prudent course would have been to consult with counsel, the record did not show that such consultation would have produced any fruitful alternatives. Here, the opposite is true. The note did not expressly state that the deadlock applied on all counts, and it is patently clear from the affidavit submitted in support of the defense motion that consultation with counsel may well have produced a fruitful alternative, namely inquiry regarding whether the jury had reached a unanimous verdict on any of the three counts, which, according to the information from jurors A, B, C, and D, would have resulted in acquittals on counts 1 and 3. You cannot argue with this argument. I mean, it's pretty solid. I'm sure they will try away, but it's a pretty solid argument. We couldn't object. You didn't give us an opportunity. Our silence doesn't mean that we consented. And clearly, if we had the opportunity to ask any kind of question, we might have gotten some kind of a fruitful alter, outcome. Something good could have come of that where they could have had a verdict on two of the three counts. In any event, Fuentes did not alter the court's clear obligations repeatedly reaffirmed since that decision before declaring a mistrial. One, counsel must have been given full opportunity to be heard, and two, the trial judge must have given careful consideration to alternatives to a mistrial, which she did not, and they've already explained that. So the Commonwealth cites no support for its suggestion that an attorney who receives a call post-trial stating that the jury had acquitted his or her client must simply hang up the phone and not act upon this information. Oh my God, this is brilliant. Okay. I mean, seriously, what are they supposed to do? Not talk to these people because they want justice to be served and not just the justice that the Commonwealth wants to serve? Ridiculous. The jury's agreement that Ms. Reed is not guilty on counts 1 and 3 reflects the results of its deliberative process. Motion at 4 omitted, not the contents of jury deliberations or thought processes of jurors. So it is the results of the process, not the process itself, not the steps taken in the middle of the process. It's the outcome of what the process concluded, if that makes sense. All right, so the defense is not relying upon jurors to attest to any particular statement made or indictment that occurred during the jury's deliberations. The effect of anything on any juror's vote or any juror's mental processes concerning a verdict. Rather, the defense is relying upon the simple fact that the jury's agreement that Ms. Reed is not guilty on the relevant counts. The permissible subjects of juror contact listed by the Commonwealth are not exclusive, and the Commonwealth fails to cite any authority establishing that the fact of a jury verdict constitutes a prohibited subject matter under Rule 3.5C. In your face. In your face, Lolly. That was beautifully written. There's no law. You didn't cite a law. There's no reason why I can't ask the outcome. I'm not asking how they got to the outcome. I'm asking the outcome. No reason why it should be prohibited, and no reason why the defense attorneys can't talk to a juror for this reason. So you didn't prove, like, they tried to almost, in effect, like, get Alan Jackson and David Yannetti in trouble because they were talking to these jurors or intermediaries of the jurors. When they came to that, I mean, the jurors came to the attorneys, or the intermediaries came to the attorneys and willingly gave that information because the truth needs to get out there. I mean, you got to shine light on this stuff. All right, so at the same time that the Commonwealth criticizes the defense for purportedly infringing upon the jury's deliberative process, it also paradoxically faults the defense for reliance on hearsay. But the affidavit by counsel in Commonwealth versus McCallop attesting to alleged juror bias was no less hearsay, and the Supreme Judicial Court squarely held that it entitled the defendant to further inquiry on the subject. Bam. There you go, Bev. You have to give us inquiry into these jurors as to what the outcome of their verdicts were. The defense admits that the same result is warranted here for all of the reasons set forth above, as well as in its operating motion, supplemental memorandum, and attached affidavits. The defense respectfully requests that this honorable court issue an order dismissing counts 1 and 3. That is signed by Martin G. Weinberg, David Yannetti, and Alan Jackson. What do you guys think about that? I think um I think Judge Bev is going to try to fight this. I don't think she's going to want. Why is she silent? First of all, like, she's been silent this whole time. She should have done something immediately to try to correct it. But no. Then the Commonwealth objects and says, "Nope, to hell with the Constitution. We're just going to try her anyways." Double jeopardy? Never heard of it. Um it's just ridiculous. And I'm so sick of the BS of this stupid Commonwealth. I think everybody is like, very rightfully so, wanting to see justice happen to many people involved in this story, like Proctor or Yuri Buchanan or the people inside 34 Fairview. I really want to see Judge Bev get her justice because I think she had a whole lot to do with the fact that this is a mistrial, the fact that she wasn't acquitted fully. Within minutes, she should have been acquitted by the way that this trial went. So I really think that Judge Bev has a lot to do with how the outcome of this trial was, in my opinion. And I really want to see justice on her. Like, she's the number one person that I just want to see justice on. I cannot stand her. I mean, maybe she's a nice person to people around her, in her life, but I doubt it. People that are that miserable are usually that miserable everywhere. Um, and it has to do again with the whole, Karen's an outsider. Karen doesn't belong in my county, and this is my courtroom, and she's not bringing in these hotshot lawyers into my courtroom. And just think that there was a big ego going into the whole thing, and that was Bev's ego. And I want to see her held accountable. Sadly, she probably won't. I really hope that the feds have been watching her along with everyone else. They have to be, right? I mean, I don't know. Bias versus purposely purposely performing misconduct or being corrupt. is a little bit harder to prove. You can say, oh, well, Bev's just biased, but I really think she's corrupt too. I don't know. I just have a feeling that this runs so much deeper than we all know. What do you guys think? Let me know in the comments below. And let me know if there's anything else that you want me to talk about regarding this case. I do want to let you guys know, I'm excited to let you guys know I'm going to be doing a deep dive on the Sandra Birchmore case very soon. So look for that. Please hit the like button on your way out and make sure you are subscribed so that when the Sandra Birchmore and more Karen Reed videos come out, you get a notification. Thank you guys so much for being here. I appreciate you so much. Take care. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.